5 DWI cases, 5 life-changing mistakes, but one case stands above the rest. From devastating drunk driving crashes to suspects found unconscious behind the wheel, these courtroom moments reveal how a single reckless decision can change everything. And when you reach case number 3, you'll see why even the judge could no longer stay patient. Watch closely, because these cases only get more shocking as they unfold.
Gentlemen, I'm bringing all of you here now because I don't want to repeat myself 15 times. All of you stand charged with driving while intoxicated. All of you are facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause on each of your cases. Each of you have the right to remain silent, the right to have an attorney present. If you cannot afford one, one will be appointed to you. Let's start with Mr. Acosta.
The officer initiated a traffic stop after observing the defendant drive without headlights at 8 p.m. Upon contact, the officer observed red glassy eyes and an odor of an alcoholic beverage. The officer called the Spanish speaker to assist, and in plain view on the passenger front seat, the officer observed an open and an empty bottle of alcohol. The defendant—
Drinking while driving? Is that what you're saying?
There was an open container, Your Honor. And the officer conducted standard field sobriety test. The HGN was unable to be completed due to the defendant's failure to follow instructions. The officer then transported the defendant to JPC, where DICs were read. The defendant consented to breath, with the results being 0.132 and 0.140.
What did you say the stop was for?
For driving without headlights at night.
Mr. Acosta, I'm going to find that there's probable case. All right, let's go with Mr. Mason.
Yes, Your Honor. On November 29, 2024, the officer was flagged down by a witness at Tomball Parkway. The officer observed the defendant's parked vehicle on the #1 lane northbound feeder road with hazard lights on. Upon contact with the defendant, the officer observed the defendant to have red glassy eyes and a strong odor of an alcoholic beverage. The defendant admitted to drinking prior to driving. Standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 1 out of 8, and one leg stand 0 out of 4. The DIC was read and defendant consented to breath. The results were 0.093 and 0.089.
So he was by himself?
He was by himself, Your Honor. He was just stuck on, park. His vehicle was parked in northbound feeder road with hazard lights on.
Got it. Okay, I see it. All right, Mr. Mays, I'm going to find that there's probable cause to go forward with your case as well. Lastly, Mr. Ulloa.
Yes, Judge. On December 1st, 2024, officer conducted a traffic stop on the defendant's vehicle after observing it run a red light at an intersection. And upon contact, the defendant was observed to have a strong odor of an alcoholic beverage, red glassy eyes, slurred speech, and was stumbling. The defendant stated he was coming from a bar and admitted to drinking prior to driving. Standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, one leg stand 3 out of 4. He was read, but the defendant refused, and a search warrant was signed and executed.
Have you checked on all 3 to see whether they have other DWIs, prior DWIs?
Acosta has no priors, Mesa has no priors, and Ulloa also no prior DWIs.
Gentlemen, I don't know what your immigration status is, but if you are not in this country with permission and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck like Chuck in custody until these cases are over with, and then you will be shipped off to immigration or you will sit for another 6 to 9 months waiting for immigration to do whatever they're going to do. If you do not have a Texas driver license, you are not allowed to drive. Do you understand?
Yeah.
Are you
Yes,
this
sir.
United States citizen? Are you in this country with or without permission, sir?
Sin permiso.
What happens if you go to jail? What did I just tell you? Did you hear anything that I just said?
Vuelvo a mi país. Regreso a mi país.
With me, send back to my.
And how long will you sit in custody for that to happen?
9 meses, 6
9
meses.
months. Yes.
Likewise,
De igual manera.
are you in this country with or without permission, sir?
Without permission.
Do you understand everything that we said? You as well. Are you here? Are you a United States citizen?
No, with permission.
What type of permission do you have?
At work.
I don't know whether you're lying to me or not. And Mr. Ulloa, it really doesn't matter. But I'm trying to warn you of the consequences of what happens if you go to jail. It really makes no difference to me whether you're this, whether that, I don't care. All I know, gentlemen, I want my streets safe. And if you don't have a Texas driver license, you're not allowed to drive. Each of you will be signing a promise with me that you're not going to drive. And I don't care what your reason is. If I find that you drive, and I don't care, if Jesus comes from heaven and needs to ride to church, you get into a car and drive, we will have issues. Do you understand?
Yes,
Do you understand?
yes, sir.
Do you understand?
Yes, sir.
Do you understand? Likewise, I'm ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or any illegal drugs, likewise, you will go to jail. No more PR bonds for you. Do you have a Texas driver license?
No, I haven't gotten it.
What's funny?
Qué gracioso.
No, que siento culpa porque pude haber evitado muchas cosas.
No, I just feel guilty. I could have avoided many
Stop.
things.
I don't want you to say anything. You're in enough trouble as it is right now. Don't make things worse for you. The only 3 things I'm asking for you, don't drink, don't use illegal drugs, don't drive, and stay out of trouble. As long as you can do that, gentlemen, you and I will be fine. If I find that you're a danger to my public, I will put you over my knee, treat you like a child, and spank you like a child, but I will do it with a ton of jail time. Do you understand?
Yes, sir.
Okay, sir.
All right, we're going to reset each of your cases to give you time to hire a lawyer. So what's going to happen now, gentlemen? I will have you come up here. Each of you will sign a document promising me that you're not going to drive. After that, I will get you to Ramona, where each of you will sign a reset. You're going to get you out of here for you guys to go hire a lawyer. After that, you will each get with Felicia for your bond conditions, so you sign and so you know exactly what you can and cannot do. After that, you will be free to go. Gentlemen, you are lucky that you're not in custody now. Make the most of it, because the next time you go to jail, you may not get as lucky. And I'm telling you, on any given day, I have about 10 people that are sitting in there with immigration detainers. Don't push your luck. All right.
Thank you, sir.
We all make mistakes, right? But you can't keep making mistakes where you endanger other people's lives. It's not fair. You know, when it's so easy to hit one damn button on your phone, for $30 to $40, you have a car waiting to take you anywhere you want to go in this. Do you understand?
Yeah, yes, sir.
I want you to understand one more thing. It's unacceptable the way that you have been treating us here in court. You were ordered to get an interlock. You have not had an interlock since August. It's not.
Judge, she did have it installed. There was a,
If it's in
There's one money.
lockout,
I understand, and there was a
it's as,
issue with the money and all that, but yes, sir, we understand.
you don't wait. If
You
you,
communicated it with me, I didn't realize there was another option, Judge. And so I'm definitely taking the heat on that. So I came in
No,
to see if we could.
I'm not going to let you. You were old enough to know that if you're ordered to have an interlock and it's not functioning, you're going to upset a judge. Do you understand?
Judge,
Just,
I'm gonna have to speak on that one, okay?
Yes.
Because I definitely communicate.
Let me know.
I said, I've been employed my whole life. When this stuff started happening, especially with the stuff with the other situation that happened going on, I let him know that I can no longer afford it. I didn't know there was another option.
And I neither, I told her we need.
But- and I
since
have not-
August, she's been in lockout, Max.
I'm not drove, I have not drove, I Ubered everywhere I've been.
It's true.
I have.
And I helped her with that as well.
Yeah, yeah.
She has. She did. But it's.
So now I'm self-responsibility for it, and I just don't want you to think that I just deliberately disobeyed an order. I didn't have a choice, and I communicated it with him. I'm taking full responsibility. So for you to tell me that, oh yeah, I mean I am old enough.
If you
and I
see,
understand.
the lawyer has been notified and still nothing is coming of it, you got to come to court, you know? When you have an interlock, it's supposed to be operational. And when it's not, that's a bond violation and it's a continued one, you know?
I understand.
I'm
taking full responsibility.
preparing you for the future, you know?
Yes.
Hopefully there is none, but you can't keep it.
Also, before all of this and the federal thing, she never been in trouble before. So this has been like.
No, I have an assault from 2010. I've got an ag assault in 2009. I've got a gun case. It's not our first rodeo.
Yeah, Judge.
It's not.
Okay.
And just,
She's like really upset about
the idea is we all make mistakes, like I told you, but don't make a mistake. I'm sorry. It's not a mistake. They're actions that you take, and you're old enough to know that actions have consequences, right? Especially when you're dealing with alcohol and a 3,000 to 5,000 pound missile that you're in. You could cause catastrophic injury, and that's what we're trying to prevent.
Understood.
All right. I am going to waive the fines and fees now, but you need to understand on a second offense, it's a minimum of $6,000 in surcharges and fines and fees if you pick up another DWI. So when people continue to make actions where they endanger other people's lives, it gets extremely expensive, not to mention costly with jail time. You understand? All right. The agreement you've worked out is 3 days in jail, credit for the 1 day that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement today, you can never change your mind. You can't say, well, I didn't know this was going to happen. I didn't know this. Once you plead guilty, it stays like this forever. Do you understand? You still want to do this? How do you plead to the offense of driving while intoxicated? I'm going to find you guilty. I will sentence you to it. I'm going to waive your costs, your fines and fees. There is a license suspension that is attached to this. I am going to suspend your license. I'm going to suspend it for 90 days. Do not drive until you get a license. Good luck, man. Thanks, Max. Please. Guys, we're talking about Akin Pelu. Is he on the docket today or no?
No, you just want us to come back.
Let me give you a cause number, guys. And
I remember this case, Judge.
I'm at a loss of everything, you know. You're on 2 different felony probations, both of those for driving while intoxicated. Both of those are felonies. So it's not only the second DWI, third. Get on probation for both of those. And now you've picked up here, driving on a suspended license. We ordered you, number 1, not to drive, and number 2, not to consume alcohol. That's all I've ordered you to do. Just don't consume alcohol and don't drive. Has anything happened upstairs?
Well, Your Honor, to be fair, I think the integrity of the machines are in question. 11/7. So when he picked up the first one on 10/29, you told him to test Monday and Thursday.
You mean picked up what? The machine?
No, when he when you thought it was a tamper on 10/29, he started testing Monday and Thursday. which in this case helps us. So on Thursday, 11/7, he was here in court where he tested. He tested at 12 o'clock. At 11 a.m., they got a tamper and a sign of alcohol. However, he tested clean with the test you told him to take that day. So which tells me that that machine's integrity is not correct. So if the integrity, and he's maintained that he has not been drinking either time. Every time we did the court, I promise he's not drinking. So if that machine is saying tampering alcohol and he goes and tests on 11/7 at 12 p.m., an hour after the tampering in alcohol, then he may be telling the truth. And I understand what we're dealing with, but he has tampering, sign of alcohol, and then it dissipates and there's nothing there. So
I'm on the same page as you as far as I never want to punish someone who's never done or who has not done anything wrong. That's not, we don't do that. We're the exact opposite. I mean, I scrutinize every single thing that Michael does, every case, every probable cause, I don't think I scrutinize the hell out of it. But at the same time, I also do that with people that are in front of us as well as people with charges, right?
And Your Honor, and to say off the record, I know that you do that. I know that you are a judge that will be very fair in these situations. So I'm just saying that.
So he takes a urine sample. It looks like on 11. What day was it?
11/7.
11/7.
I think the sample was taken around noon. He did two that day, one upstairs and one downstairs. So 11 and 1 o'clock. He had to do two different samples. 11, I think 07, they say he tampers and a sign of alcohol occurs. So he was here in court, but still have two urine analysis around the same time as that he.
Alicia,
Yes,
do you
Judge?
have a test for 11/7? Because I don't have it.
Yeah, so it's probably not in those records because right now it's just presumptive. It was presumptive, but it's negative. So nothing came back. I have it on my end here. It should be.
What time was the positive for alcohol on 11/7?
For the scram report? Let me see.
I thought it was like 11 a.m.
Sorry, normally I don't look over those reports because I don't know how to use them, but I will try to figure it out.
Hey, Judge, I might have an unupdated report. The only BVR I have here is for a scram violation from October 30th.
Yes.
Was there another violation?
Yeah.
Okay.
So there's a violation technically pending on our end because he was coming in that day, so I addressed the violation. And so they were waiting to file it to see if judge wanted that to be filed because he was going to address it at court. And that's what we're discussing from 11/7. So that violation is pending a UVR because judge is taking action on it already.
Do we have a,
I could have sworn you said that there's another presumptive alcohol
On 11/7.
on 11/7.
No, there's a presumptive negative for the POC test that he took, our rapid test.
No, yeah, right.
On
I know that
11/7,
one.
it was a alcohol detected, but. can't
What
be
time was that?
confirmed. I'm trying to read the report.
Because
I
that's,
don't know how to read the
see, we've got a
So I
presumptive.
got it right here from Brittany Gordon. The defendant order was to obtain a scram device. The defendant's scram device has confirmed one tamper event. The tamper event occurred at 11/7 at 12:42 p.m. Now he was taking the test at 12:30
Hold
p.m.
on. Saying it was 11/7.
At 12:42 p.m. Got this email on November 11th. It went to everybody in the court. And alcohol was detected during the tamper. However, alcohol cannot be confirmed as consumption because of the nature of the tamper.
Began at 2:25 PM and returned to baseline at 8:04 PM.
We also took another test with you guys on 11/7.
Yes, that was at 12:47, I believe. Let me double check.
What? So at 12:42, he tests positive for alcohol, and then at 12:47, he tests negative for alcohol. Am I right?
It was, sorry, one, two, it was Tuesday, October. I'm sorry, Judge, respectfully, I have no idea how to read scan results and everything that's in my email, but I can check on the drug test for you.
Well, so the 11/7, we have the email on November 11th, okay? Then if you go to the email she just sent me, it tells you when the lab test was submitted. Hold on. You just sent me this email. And this email from Average Size Individual Screening Report on 11/7, it says that it was one of the collection times was at 12:08 PM on 11/7, 12/24. He did negative. So that means while he was in court, he would have to drink. But then he took another test after that. What I'm saying, Judge, I'm gonna say this whole, if we were in trial right now, the whole integrity of these machines would be in question right now, because in the previous test, because the same exact message that we got on 11/7 was the same exact message that we got on 10/29. Scram temper, alcohol cannot be confirmed, same thing. So what I'm saying at this point, he has maintained to me, and I know he's messed up numerous times. He's maintained to me that he has not touched alcohol since his last situation. He did drive, he's wrong for that. But these new testing procedures that he's got,
What do you mean he did drive?
that's why we're in here, because he was driving.
So due to the charge, though.
Yeah, he did drive.
I hope to God that you're not driving this drunk.
No, I'm talking about due to this charge, while we're back in your court.
Okay.
Judge, I don't have any of those emails. I think the best thing at this point is we can set this off for a bond hearing, and I can bring Ronald Grant here to clarify all of this with all of us, because none of us are experts. We don't know how to read the report. I know what defense is saying, but I can't even tell you the veracity of anything that's happening because I don't even have these emails.
Yeah, so
I can subpoena Ronald Grant. We can do this next week. I can get it done.
let's not disrupt other people's lives. It's not necessary.
Sure.
He is saying that we have a test, and I mean, what Mr. Evans is test 11/7, the scram at 12:42, there's a positive, but then 7 minutes later, there's a negative when he goes up there to test. The machine's obviously messed up if that's true.
Is that what you're saying, Felicia?
And then I've also noticed on the screen report, I asked them, because again, myself, I cannot acquire this. I have to have it provided from our case managers and the provider of the device. But the screen report, the only one that I'm seeing attached to the email is for the DVR that was filed for the 29th, but I'm not seeing the one from 11/7.
So we don't have a scram report from 11/7.
We have an email.
It's not attached in the email, but we do have the rapid test when he was on site.
The rapid's negative.
Yes, and then we were informed, like I informed you yesterday, of the pending BVR violation for the 11/7 at that time.
Hold on. So, Judge, we don't even have the scram report. We don't know what the presumed blood alcohol content was. It's very possible that if he had a very low blood alcohol content or breath alcohol content, that the scram detected that he could have come to court, taken a test and gotten a presumptive negative because it's already been eliminated from his system. That's why I'm saying I believe we need to get that scram report from 11/7, get what the tamper is, have Ronald come up here and tell you what's possible or what's not possible, because he's the expert, and I get what defense is saying, but he doesn't know either.
But
I don't think.
let me respond to that. What we do have is a test that happened at 12:07.
Right.
And I can show you that one. So even if we don't have the one that she spoke of, a 1247 that she referred to, we have a test right here, which will make us have to believe that he, while in court, he drank some alcohol if these machines are deemed to be valid. And we were about to reprimand him for the 11-7 situation, but now it's time to.
Reprimanding or remanding, or he's suggesting that we just do it at a later time to get everything all together.
Okay, well, in the meantime, since these machines.
I'm not gonna take him into custody until I know 100%.
But can we, because he's working, he's come here. The reason why you put him on Monday, Thursday is because these tamper going down. So we're gonna wait to see if these machines are valid. I'm requesting that we go back to the same bond conditions that we had prior to the tampering. So he does not have to miss work twice a week, coming out here and testing, because all we know, this could be a big mistake.
And I would strongly object to that, Judge, based off what he's on probation for right now.
But the only reason why we're doing the twice testing is because of the tampering. So if the tamperings are invalid, why are we doing something extra when that wasn't what the judge originally wanted?
Well, because there's an allegation right now. We need time to confirm or deny that. But for now, the safety of the community warrants these bond conditions, in my opinion, Judge.
And I strongly disagree.
Mr. Evans, we have a curfew on, right?
I don't think we have a curfew. We just have to scram. You just have
He
to
has a
scram.
curfew, Judge.
Yeah.
Well,
So,
so, okay.
so,
Are you working now?
yes, sir. Working with a hospital in, I have a project with Epic. So I assist physician and nurses on the software they use called Epic. The software is called Epic.
I don't want anyone to lose a job. I mean, the last thing I want is someone to lose a job, right? But I have to know that you're not drinking. I can tell you. I know that you tell me no, but all I have are consistent problems. Every time we had you on docket for whatever it may be, there was always problems. Every single time you came in here with the DWI, there were issues. Every time you came in here with the suspended license. And I'm telling you the history that we're having, you know? So that's why it's hard to believe all these coincidences when the nature of my relationship with him was every time we had a case, there was at least 3 BVRs, every single.
And I was completely on your side. I thought he was telling me not the truth. But once I saw that he was in court that day.
Let's do this. Let's set it for next week. Let's get.
Is that possible? I'll be in trial next week till about Wednesday. Can we do next Friday? Okay.
Or not Friday, Thursday? Or, okay.
Friday's okay? Yes, Judge.
Yeah, and do you want me to waive the appearance?
I just want you to waive the test.
Oh, okay, I will.
Yeah.
I will.
Yeah, that's all I want.
He's got to be here for the next BVR here.
No, yeah, that's fine. Yeah, I just want him to be able to work. So thank you so much.
I'm tired of having to deal with one problem or the other. I would suggest that you go get a new machine so that we know that there are no more issues. Go down there, tell them, hey man, give me a new machine so that we know if there are any issues, that way you can make sure that you get a new one. Felicia, can we send him for a new one now?
Yes.
Just to make sure that, Okay, so you guys pick it, we'll do it. And then we'll do it. We'll take them off that.
Thank y'all.
Yeah, we'll stop for now. Yeah.
So you sent me the test upstairs, right?
Right, compel witnesses to testify on your behalf. Confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. You will never be able to take it off. Do you understand? You also need to understand that if you get pulled over in the future, you're in a car driving, An officer, the first thing they do is they look at your driving record. If they see a prior DWI and they come up to your window and they smell alcohol or they smell something funky, it's not going to go well for you. And from now on, you are facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand?
Entiende? I do.
All right. How do you plead to the offense? Guilty or not guilty?
Guilty.
I will find you guilty, send you to the agreement. Good luck to you, sir.
Buena suerte, señor.
Thank you, Judge.
The fee. The fee.
Wait, the thing, okay, is it?
So, hold on, Tony. I need you to tell him one more thing. I want you to understand something.
Usted entienda
That
algo.
DWI is extremely big business in Harris County and in Texas. There is a $3,500 surcharge that typically would apply to you
3,500
on these types of cases. I will waive it for you now because it is a first offense. On a second DWI offense, it is a $6,000 surcharge. And if you don't pay it,
Si no lo
you do a
paga,
ton of jail time.
están en la
Do
cárcel.
you understand?
Tiempo. ¿Lo
So
entiende?
get a clue. If you want to
Entienda.
drink, don't get into a car.
Metan un carro.
All
Thank you,
right.
Judge, appreciate it.
I have two on the docket. It looks like one is going to work out. Natalie Garza looks like it's going to work out.
Okay.
Once we get restitution established, that one should be dismissed. But we're just not there yet, but we're all in agreement.
Okay.
We just need to make sure that the number is correct.
It's kind of old though, and we've had the restitution, $500 restitution at class for dismissal since January.
We're just waiting to get the proof of the insurance from the complainant. I called twice just now and I'll call again this evening to see if I can get a hold of that today.
I'm gonna roll it a week.
I'm cool with it. We're in agreement, Judge, so a week is fine.
Got it.
And hopefully if they can get it earlier, we'll get it in earlier and she doesn't have to appear. And also, Judge, I understand that Tristan Smith needs bond conditions for the second case, so I'm here to approach on Tristan Smith.
We didn't do conditions on it?
Oh, we did. Victoria said,
Condition.
I think we're good.
Tell me, how are things going? Great. Okay. That's the best news I've heard all day. Really.
They like enrolled me in Channel, but I wasn't gonna be able to go to Channel anyway because it's too far of a commute. So
Yeah, that's crazy.
yeah, so they just enrolled me in Humble High School. So my first day will be Thursday.
Knowledge is power. When you know things, you can do anything. I'm telling you, ask him. When you have knowledge and when you know things, it can take you so far in life. The only way you do it is by doing school, taking it seriously, and not letting other people drag you down. Because that's what you constantly have is people around you trying to bring you down. Don't let them. Be stronger. Right here, that's where it starts. When you see someone trying to take you down, even though, hey, let's go out, let's do this, that, it's bringing you down. Don't let it. Be stronger. Be strong-willed. Make something of yourself. And it starts. Prime example right here. He's amazing, right? That's a great role model right there. You ever need anything, that's who you follow. We have things here that we can help you out too. What conditions do we need?
I thought that we needed
Alicia,
somebody.
do we?
Did you want me to go over the ones that we have?
No, I mean, I think that the only thing we need is just stay in school, get a job. I would prefer you stay in school, get as much education as you can, so you become someone, go to law school. It's an amazing field. I'm telling you. Okay. I mean, I think we're good,
Yes, sir.
just don't pick up any new cases. Be good.
In this gripping courtroom session, multiple DUI
Gentlemen,
defendants stand
I'm bringing all
for
these,
being caught
so
driving
with Mr. Mason.
Yes, yes, Your Honor.
Well,
accidents.
lastly, Mr.
One
Ulloa.
driver was stopped for driving
Red
with
eyes,
headlights
slurred speech, and was stumbling. The defendant stated he was coming from a bar.
Another was found parked in a traffic lane after drinking, while a third admitted leaving a bar before being stopped for running a
Gentlemen.
red light.
I don't know what your immigration status is. You're with or without permission, sir.
A stern warning about the dangers of impaired.
I don't know whether you're lying to me or not, and Mr. Ulloa, it really doesn't matter. But I'm trying to warn you.
The hearing becomes
Do you have a Texas driver license?
when immigration
You can do that.
consequences are discussed.
Gentlemen, you and I will be fine.
Defendants warn
If I find that you're a danger to my public,
could trigger lengthy detention and
know exactly what you can and cannot do.
Another
After that, you will be free to go.
that repeated
Gentlemen,
Installed, there was a.
if it's in lockout,
I understand, and there was a.
it's as since August, she's been in lockout, Max.
I'm not drove, I have not drove, I communicated it with him, I'm taking full responsibility. So for you to tell me that.
Look,
one
I'm
message
I'm taking full
I'm
responsibility.
preparing you for the future, you know?
Yes.
Hopefully there is now, but you need to understand, on a second offense, it's a minimum of $6,000 in surcharges and fines. You accept this agreement today, you can never change your mind. You can't say, well, I didn't know this was. Both of those for driving while intoxicated.
reminder that one night of
Both of those are felonies.
Submitted.
The real
Hold
question
on.
is, how
Court
many
that day.
warnings should someone get?
Let's do this. Let's set it.